This is an indictment of the state of Florida against Theodore Robert Bundy, alleging 2 counts of murder in the first degree, an attempted murder in the first degree, and burglary of a dwelling.
This is the state of Florida versus Theodore Robert Bundy for July 23, 1979. And I'm Ed Hula reporting from Miami, Florida. The defense rested its case today. The final testimony came during a session of court scheduled this afternoon so that attorneys for prosecution and defense could meet with Judge Edward Coward to discuss the charge he will deliver to the jurors once final arguments are made in this case. This scheduling was done at the end of a full day in court this past Saturday, July 21st. Saturday brought more developments in Bundy's relationship with his attorneys. He announced at the beginning of Saturday's session that defense attorney Margaret Good will deliver closing arguments for the defense, not Robert Haggard, who was the choice of the defense team to make this presentation. The veto of Haggard by Bundy did not sit well with defense counsel Ed Harvey.
Judge, for purposes of the record, then, there's been one counsel on our team who's prepared closing argument for the entire trial. None of the rest of us have at all. Mr. Haggard has spent the entire trial keeping notes, preparing his closing argument. He's the only one who's prepared or will be prepared in a reasonable amount of time. Now, it's as a lawyer, as a professional, it's my recommendation. In fact, it's my wish that Mr. Haggard do closing argument. Yeah.
That's been communicated to Mr. Bundy?
Sure.
And he made the decision, or he participated in the making of the decision that he's previously made known to the court?
Yes, sir. All right.
And so be it. I think that's no problem in the record. I can recall quite a few times when clients did things that I didn't advise them as lawyers, but they still are the clients. The fact that there's a public attorney really makes very little difference.
Yes, sir.
I don't want, and I will not have, the record show that this is more than as he indicated, something of a compromise, which must indicate that as more or less the one who has been involved in it the longest since I've been involved in it, of course, has been you. And if that's your decision, that's your decision. And I have no reservation in saying to you that the record reveals that that is your position, and it does. Then we'll proceed on in a manner that is consistent with what he wants done.
Judge, I provide Mr. Bundy with a copy of this. It's a motion to redetermine Mr. Bundy's competency to stand trial and request for an evidentiary hearing. And I believe that this has to be in the record at this point. I'd like the court to make a specific ruling this time that he's competent enough to have a decision. Over my strong objections and over my recommendation.
Of course, you and I know that Dr. Tenay's record is before the court, has been before the court, and the court has considered it in its entirety. There might not have been oration of it, but there was consideration of it by the court, and the court held a competency hearing.
Yes, sir, I understand.
Has there been any further determination of any further
There's been no further examination. Yes, sir. The stand on the record is reflected in the record throughout this trial.
Let's say the state.
Well, Judge, I think everything that the record has reflected is just exactly what we brought out in the evidentiary hearings in Tallahassee. The man is difficult to work with. He's almost cunning in the way that he works against his lawyers sometimes, and he reaches a level where he's unbearably hard to work with. But all of that notwithstanding, the doctors told us that it does not meet the test for legal incompetence.
I think Dr. Tanay indicated that.
Judge, he indicated there was a true question that was up to the court.
Well, I think the court has ruled on it. I'm trying to make a determination of need for further evidentiary hearing.
Judge, I think that if we do need it for evidentiary hearing, because I believe that if we were able to fully develop Dr. Tanay's testimony, we did not choose to cross-examine Dr. Fleckman. We did not choose to question Dr. Tanay because at that time it was pre-trial and the person was allowed to be in the hearing. At this time, we would be able to...
Tanay's entire report was filed of record.
Yes, sir.
The court has considered it.
Yes, sir,
The
Judge.
court considered it when I ruled.
Yes, sir.
And I think Dr. Tanay's observations are in fact manifested. But Dr. Tanay's observations and Dr. Tanay's conclusions did not set forth the legal standard upon which incompetence. I've never seen anybody that I think really is more cognizant that a trial is going on. Now, while he might not be able to communicate with his attorneys, he has communicated a great deal to the court and to his attorneys in the standpoint that I don't think there's a question of this man meeting the legal standard, his competency to stand trial. Probably the best evidence of that is from himself.
Harvey's motion was denied by Judge Cowart, who said that the previous testimony on this issue indicated that Bundy was competent to stand trial. Then Harvey followed by asking Judge Cowart to allow him to withdraw the staff of the public defender from the case. Cowart refused this motion too, and Bundy responded to this pair of motions and said they indicated the problems he was having communicating with his lawyers.
But I think it points out a problem that we've had in communication, and I wouldn't want to point it out, make it clear that these things constantly come back on me and make it look bad, when in fact, last night when we had this conference that I just told Your Honor about, there was unanimity amongst the group that this was going to happen, as I told the court. There was no suggestion at that time there was going to be any motions on incompetency or any motions to withdraw. Yet I come here this morning and I'm ambushed, and people want to make me look.
You haven't lost yet.
Haven't lost yet. I don't intend to. But if I had decided to do closing argument, I think Mr. Harvey had a point. If I wanted to get up there and talk to the jury about the evidence we've heard in this trial, they should carry me away right now. Probably would.
Do you want to make closing argument? I'll arrange for you to be carried away.
Who are you working for, Your Honor? I said that. I'll supply to the court. I think it's important to supply to the court a written statement, perhaps, because I don't like to be made out as a fool or a difficult client. I hope Mr. McKee would think I'm difficult, but that's because he was on the other side. I think I'm in a position as well.
Oh, Mr. Bundy, in pure legal circles, I'm sure you're not the most congenial client in the world. Lawyers are part lawyers, never are. No. I represented in my career quite a few lawyers, and I was always glad when their cases were over.
I'm sure. That's enough said. Let's get on with it. I'm to see how closing argument goes.
I'm hot to try. I'm not really slow down to anything.
Well, Your Honor, I have one brief motion. Since I stand in the special posture of the Office of Complementary Counsel, and Mr. Bundy's Sixth Amendment right to effective assistance to counsel will not be affected whatsoever, I would seek leave to be excused.
Your objection to that?
No, Your Honor.
Thank you, Mr. Bundy.
You're excused.
Thank you.
And then there were three.